Okay, so this is how Gideon v. Wainwright went down.
It's 1961, and this guy named Clarence Earl Gideon is accused of thievery of a pool hall in Panama City, Florida. He's charged with a felony, and he's too poor to afford a lawyer. So at his first trial, he asked the court, "Hey court, can you guys provide me with an attorney? I'm too poor to get one." And the judge was like, "Nah, can't do that for you." Because under Florida law, lawyers were only provided by the courts if the defendants were charged with capital offenses. So like murder and other serious charges, but not burglary. So he had to represent himself, and it didn't go so well. The jury found him guilty, and he was sentenced to 5 years in prison. He's like, "That's messed up. I gotta do something about this." So he petitioned for a writ of habeas corpus in the Florida Supreme Court. He tried to challenge his conviction, saying, Yo, listen, I didn't have an attorney, so I was denied a fair trial. The Florida Supreme Court said no, but he didn't give up. Probably did some studying in prison. He sent a handwritten letter to the U.S. Supreme Court, a petition for a writ of certiorari, requesting that the court review his case and appoint a lawyer to defend him this time. At this point, the Supreme Court had already dealt with several cases surrounding the issue of the right to counsel. In Betsy Brady in 1942, the courts decided that assigned counsel was not required in felony cases, except if the defendant was illiterate or mentally challenged. The Supreme Court took up Gideon's case in 1963. And they appointed Abe Fortas, a renowned lawyer and future Supreme Court justice, to defend Gideon. The Sixth Amendment of the Constitution guarantees the rights of criminal defendants, including the right to a lawyer. It says, "The accused shall have the assistance of counsel for his defense." Now the question was, does it apply to the states? Does the Sixth Amendment apply to the states? Well, it turns out it does. The Due Process Clause under the 14th Amendment says no state shall deprive any person of life, liberty, or property without due process of law. So the 14th Amendment basically forced the Sixth Amendment onto the states. The Supreme Court, in a unanimous decision, declared that poor criminal defendants have a constitutional right to a court-appointed lawyer. They reasoned that you can't have a fair trial without a lawyer. It overturned Betsy Brady, and now all state courts have to provide lawyers for defendants who can't afford to hire their own. Oh, as for Gideon, he was granted a retrial and was acquitted of all charges in 1963.
So, yay for fair trial rights. But it is questionable whether this has actually been good for criminal defendants. The public defense system is so underfunded and public defenders are so overworked that it actually works against them. There's a report that found that many court-appointed lawyers spend less than 6 minutes per case at hearings, where they counsel their clients to plead guilty. And today, elected officials don't see any political value in putting money into the public defense system because no one cares for criminal defendants. So our criminal justice system is still screwing over poor people. And yeah, that's Gideon v. Wainwright. Sorry, Gideon, we have yet to fulfill what you fought for.